today?
Yes, my lord. As agreed by both parties, my lord, if it can be taken up some other day.
We keep praying for adjournments. Where's Miss Valentina?
She's,
See, you had prayed
on
for this matter to be heard today. So this court had the, you see, we had also done our homework and looked through the case to see what is it all about. And then you come and pray for adjournment straight away. Anyway, as prayed for by the learned counsels for both the parties, list, when you want it? List after
in
2 weeks?
2 weeks, my lord.
List after 2 weeks. Yes.
Obliged.
My lord, if I may make one, my lord, one submission regarding item number 3 of part 2, my lord.
3. We have already fixed for some other day.
I'm sorry, my lord, item number 4.
4.
Item number
Yes, today.
Yes, my lord.
Ah.
So in this matter,
Yes.
is it listed for today, my lord? Then I'll wait till for the hearing to come up, my lord.
Who is
Because
the
this matter
counsel?
has been settled, my lord. That's the thing.
It's settled.
It's settled. My learned friend, I'm not sure why he's not here. But this matter, my lord, pertains to alimony and also divorce.
Oh.
Now what happened was, my lord, as per
You're the one who filed the appeal, isn't it?
we filed the appeal.
Ah.
Now what happened, my lord, was the divorce, as per the impugned order, would be subject to the payment of the alimony, my lord, by us. Now in the meantime, what the parties have done, my lord, they came to a settlement. And the settlement order was made by the District Council Court, Chakma Autonomous District Council, Kamalanagar, my lord.
So if you are the appellant, you can pray for withdrawal of your appeal
No, so,
on the
so,
grounds that you have settled the matter, you don't want to appeal
so my humble
outside
prayer,
court.
my lord, humble prayer, my lord, is since it has been settled, my lord, if an order may be passed, saying, my lord, considering the fact that this has been settled, this matter is disposed of, my lord, in that line.
Okay. Because you're the appellant.
I'm
So
the
you're
appellant.
the appellant. If you feel that it's been settled and you don't no longer want to pursue the matter, it's up to you.
Yes, my lord, I have the
Okay.
order also, my lord,
Okay.
in light of this order, if this matter can be disposed of, that's my prayer, not withdrawal as such, my lord, but in light of this,
Which
this,
order?
I've placed it before, my lord, I've given it.
Come on. Give it a go first. Show me RFA, item number 4.
So, my lord, what
Here's a
has...
certificate of divorce.
Yes, and in that it has been written like this, my lord. Whereas in connection with the above case, the petitioner and the respondent have jointly submitted before this court on 5/12/2024, and accordingly both the parties have mutually agreed for divorce. Thus, taking consideration of mutual decision of both the parties for divorce, this court hereby dissolutes the marriage of Sri Sugata Priyo Chakma, son of Shanti Kumar Chakma, so and so, and Srimati Ittiko Chakma, so and so. Are hereby issued this divorce certificate to Sri Sugata Priyo Chakma and Ittiko Chakma. Thus, from this day onwards, they will no more remain husband and wife, and they shall have no right to interfere in private life of each other. Now, my lord, if your lordship will come to the paper book, my lord, at page 5.
So, your appeal, the judgment of the, what? The trial court is what? Divorcing you or not accepting your divorce or what?
So what happened, my lord? Let me explain. So the respondent, the Ittikona Chakma, my lord, the wife, she filed an application for divorce.
She wanted to be
She wanted to divorce, and she also wanted maintenance and alimony. So she filed an application in the District Council Court, Chakma Autonomous District Council.
So divorce was granted or no?
No, divorce was not granted. Let me explain, my lord. Divorce was not granted, but she was given a one-time alimony.
Okay.
And also, my lord, in the order it's mentioned, in the impugned order it's mentioned at paragraph number 9, that divorce between the parties may be granted upon full payment of the alimony so ordered.
By you?
Yes, by
So
us.
you have paid?
No, so what happened was, my lord, we were aggrieved by that order because according to us, the court simply did not have the power to award the alimony.
Okay.
So we have
The
come to this court.
alimony.
Now in the meantime, she has now, my lord, filed, if you see the next page, my lord, she has filed an undertaking saying that self-declaration saying that I, Itiko Tsakma, so-and-so, is hereby making this self-declaration in safe and sound state of mind that I will not make any claim of alimony as well as maintenance from the respondent neither now nor in future till my lifelong. So on that
But
basis,
he's not here.
on
She's not represented.
He's not-
So
she's not
she has to be represented, isn't it?
Yes.
Then if she admits this,
And then on
then
that
there will
basis,
be no grounds for you to file an appeal, because your appeal is only regarding the alimony.
correct.
So unless she also agrees to this, then you will have to abide to this court's order and pay the alimony.
No, so now as
So
per
she
this,
has to be present.
she has to be present. And if your lordship will see this certificate of divorce, the last line in the first paragraph, thus from this day onwards, they will no more remain husband and wife,
Husband
and they
and
shall.
wife, it's a different matter.
My lord, and it says like this, and they shall have no right to interfere in private life of each other.
But alimony is not mentioned here. So
Yes.
therefore, I think it will be more in your favor if you have her presence here in the court, let her be represented.
Yes.
Then we can see, otherwise you'll have to pay the alimony. Isn't it? So your appeal will still stand in. Anyways, so, Mr. Joseph Lalchan Himarindle, learned counsel for the appellant is present, while none appeared for the respondents. The learned counsel for the appellant submits that the parties have come to an understanding and outside court, and a certificate of divorce dated 11 December 2024 has been issued by the Judicial Officer, District Council Court, Chakma Autonomous District Council, Kamlanagar. And because of which the present appeal may not be, could be what disposed of.
Could be disposed of because of this certificate of divorce.
Because
The
of
reason we
the-
say, my lord, is this.
So if you feel that everything is understood here,
Yes. She is married also now.
but she's not here. But you're the appellant.
I'm the
Okay.
appellant.
So if you feel that because of this you no longer want to pursue the appeal, we can dispose it off.
My lord, that's what I'm saying. In line of this, in light of this divorce
But
certificate.
we are not going to mention anything about the alimony, nothing,
Nothing.
because that alimony, she's not here to say that she's not going to. But in light of the divorce certificate,
Correct.
if you no longer want to pursue the matter, we can dispose it off.
Yes, in light, that's what I'm saying, my lord.
Okay, not because of the alimony.
That one we don't have to mention only.
Because this, we cannot mention that you're not going to, the respondent is not going to claim alimony. That we cannot mention.
Yes, but
Okay.
my lord, if we were supposed to push this case,
Uh,
this is what I want to say, my lord.
uh,
The district council court has no power to allot alimony. I mean, that's a different matter, my lord.
That's a different matter.
Yes.
Okay, so and so, what is the last sentence? Outside court, is it? Oh, because of which the learned counsel submits that the present appeal, okay, a regular first appeal, may not be required to be pursued. He thus submits that in view of the said divorce certificate duly issued by the Judicial Officer, District Council Court, Chakma Autonomous District Council, Common Learner, dated 11/12/2024, the instant appeal may be disposed of. Okay. It is seen that none appeared for the respondents. However, considering the fact that the appellant has prayed for the disposal of the appeal on the grounds of the certificate of the divorce issued by the, again, judicial so and so and so. this court find it fit to dispose of the regular first appeal on the issuance of the certificate of divorce dated 11 December 2024. The said certificate of divorce is to be marked as X and made a part of the record. Accordingly, RFA stands disposed of on the submission made by the learned counsel for the appellant.
Much obliged,
Yes.
madam.
Lordship, may I make a consensus prayer on behalf of my senior, Mr. Roshan Subedi, regarding item number 5 and 6 of the hearing list.
5 and 6,
Yes, madam.
what happened?
As my senior is having personal difficulties and that Mr. Johnny is still on legs on the other court, if the matter be listed after a week.
Now here, in one case you are for the respondent, in the
Number
other
two,
you
yes.
are for the appellant, and
Yes,
the
madam.
other you are for the respondent.
Respondent
Is
number
it-
2, in item 5.
So where's Mr. Roshan?
Your Lordship, he is having personal difficulties today.
Have you taken the consent
Yes,
of
my lord.
Mr. Johnny L.
Yes, my
Tauchong?
lord.
Okay. Heard Mr.
Lomo Moralte,
So it's Lalo Maralte, appearing on behalf of his senior, Mr. Johnny L. Tauchong.
Roshan Subedi.
Yes, Mr. Roshan Subedi. Now in MAC appeal, it will be learned counsel, MAC appeal 1, okay? Serial number 5, it will be Roshan Subedi, learned counsel for the respondent. For respondent number 1 for adjournment of the matter with the consent of the other side. Accordingly, list this matter after
A week,
2
ma'am.
2 weeks.
Yes, ma'am.
Okay. Then in serial number 6, it will be on the prayer made by so-and-so, appearing on behalf of Mr. Roshan Subedi. It will be learned counsel for the appellant, okay, with the consent of the other side, has prayed for adjournment. Then list after 2 weeks.
Obliged, my lord.
My lord, in respect of part 2, item number 12, my lord. If this matter can come up tomorrow if time permits, my lord. I had,
Tomorrow,
yes, my
make
lord.
it in the next week. Okay, because tomorrow I think there's going to be a function here, opening of the parking lot. So I don't think we'll be able to have long matters.
Okay, my lord.
Or we can have it after the program also, in the afternoon, around 3.
Yes, my lord, can we have it on next week, on the next week? my
Yes, okay, on the submission made by Mr.
lord? Ramdin Thara, my
Lal
lord.
Ramdin Thara, learned amicus curiae. List the matter in the next week.
Deeply obliged.
For admission, item number 1.
Yes,
The matter pertains to absorption of the RDA employees.
so steps were taken, so complied? Are you appointed? What happened?
My lord, the process,
Not yet,
it's
my
in
lord.
process. It's in
What is the
process.
stage? What's happening? Mrs. Mary,
Yes, my lord, the
so you have
latest
to
that,
see whether relaxation can be given to those who are overaged.
Yes.
So what is the stage now? What is happening?
My lord, for
I can't hear
my,
you. Have you mute yourself?
no, my lord.
Anyways, we'll give them some more time. Isn't it? Do you know what's happening?
Yes, my lord, as per the information I received from my client, these petitioners comprise regime of group A, B, C, and D. And for the group D, 29th April is scheduled for conducting typing test.
Okay.
And only when date is fixed, they are expediting the process. So
Okay.
if so, date may be fixed again.
Yes, okay. Heard Mr. Victor L. Ralte, learned counsel for the petitioner, who submits that he has been informed that certain steps have been taken are being taken by the respondents with regards to Group D employees. What about the others?
My lord, my lord.
I'm not aware of the others. 29th April is scheduled to be conducted.
Okay, and that 29th April has been scheduled for conducting their
typing test.
typing test. Yes, Miss, we can't hear you. Mrs. Mary L. Kente, Learned Counsel for the respondents, has appeared on online, but due to some technical defect, her submission cannot be heard. In view of the above, since it appears that certain steps are being taken by the respondents, list this matter after 3 weeks.
That will be too long, my lord.
Okay, list this matter after 2 weeks.
Date may be given, date may be given. 5th
See,
of May.
because it's only for D, what about the others? We have to see overage, what's happening. But they are taking steps, isn't it?
That is correct, my lord.
So list after 2 weeks, let's see what happens then. Okay, yes.
Date may be given.
Okay, give me a date after 2 weeks.
8th of May. 8th of May.
On 8th May 2025, yes.
Deeply obliged.
Item number 2.
Yes.
May it please Your Lordship, with respect to the order dated 14/11/2024, my lord,
Yes.
Mrs. Mary L. Kyangte has given me a copy of the document which was to be produced by the state respondents. She is inaudible at the moment, so she has requested me to,
Next date.
no, my lord, to give this copy to the court.
What does it say?
This is the latest reassessment made, my lord. So this is the new development that has been made by the state government, and if your lordship permit, since the document is slightly illegible at some point, if necessary, affidavit may be filed, she has requested.
Okay. Heard Ms. Valentina Veldempuy, Learned Counsel for the petition, who submits that the respondents, the respondent number, Mary is what? That the respondent number, who is this respondent? District
State
Deputy Commissioner is who? The respondent number?
12,
It
yes.
says that the respondent number 12 has taken certain steps while the letter dated 17 September 2024 addressed to the Senior Executive Engineer, PWD, NH Division -3, Thingdol, Mizoram. Copy of the letter. Thingdol, Mizoram, full stop. She further submits that the Learned Counsel for respondent number 12, though present through VC, being inaudible, may file the said by way of an affidavit, since certain portions of the said letter dated 17 September 2024 is not eligible. Or just make it as ineligible. Okay. Yes, then Ms. Adam Sangpi.
My lord, for respondent number 2, I already defined my affidavit, my lord.
Mr. Ramsampur, Learned Learned CJC appearing for respondent number 2 has paid for time to file
No, my
the,
lord, I already defined my affidavit.
for submits that she'll be filing.
She has submitted, my lord.
Okay, she submits that she has already filed the, you're not audible sometimes, you
Yes,
speak very fast, filed the affidavit in this regard. In view of the submissions made by the learned councils, this court find it fit to fix another date for the respondent number 12 to file their show cause reply in form of an affidavit. List after 3 weeks? After 3 weeks.
Obliged.
Item number 3.
May I please, my lord? My lord, even though today is fixed for hearing, it's a fixed item, my senior, Mr. Fakomasan, is being admitted to a hospital. He has some
What
personal
happened?
difficulty. He seems to have an MTI.
UTI is not too serious unless it's very severe. Is it that he has to be hospitalized? Anyways, then we'll have to fix another date.
Yes.
You're not prepared? It's not a difficult
Yes, my
matter.
lord. It's a limitation. So limitation, I believe it's have to be proper hearing, since limitation is a mixed question of facts and law. So
Can we admit the appeal and fix for hearing some other date? Instead of in the admission this thing, isn't it? Miss so-and-so,
Vero Pari.
Learned Counsel appears on behalf of her senior Mr. Nel Fakoma.
If I may mention one thing, my lord.
Learned Counsel for the appellant,
My lord, with this matter, my lord, the issue is, as my learned friend had mentioned, is on the question of limitation. Now, how did this issue come up, my lord, is in the preliminary hearing, my lord, before trial, in the preliminary hearing, their plaint was dismissed, my lord, their suit was dismissed on this single ground of limitation. So there is no evidence involved in this case, my lord. It's a pure, there are only 2 documents, my lord. One is the plaint, the written statement, and the impugned order. So there are only 3
But
documents.
it's an RFA appeal, so we'll admit, or most appeals are admitted, we'll admit.
Certainly, my
Okay,
lord.
and then we'll hear on that issue also. It shouldn't be difficult, isn't it?
Yes.
We will not call for the, okay, LCR is not required, no LCR?
Not required, my lord.
Okay. Her business, so you don't have to appear on behalf of your senior also?
Yes, my
Okay,
lord.
because your name is here.
Yes,
Not
ma'am.
Ms. So-and-so, Learned Counsel for the appellant, along with Mr. Joseph Lal Sanhima Rentley, Learned Counsel for respondent number 1, and Ms.
For respondent number 2 to 4, my lord.
Okay, Caroline K. Lal Molpri, Learned Government Advocate for respondent number 2 to 4. Having heard the submissions made by the learned counsels, appeal is admitted, list for hearing after 2 weeks.
My lord,
What?
next week if possible.
Okay, list for hearing in the next week?
Yes.
In the next week.
Obliged.
Item number 4.
Again, he's not here.
Yes, my lord.
This we'll have to consider admission hearing, isn't it? So, Ms. So-and-so, learned counsel, appearing on behalf of her senior Mr. Alpha Koma, learned counsel for the petitioner, submits that the learned counsel for the petitioner is not able to appear due to health issues and prayed for adjournment. Okay. Then, yes, Mr. Ricky, is it J.H.
madam.
Ricky Lalwat Fella, learned counsel for respondent number
1.
1 is present along with Ms. Caroline K. Lalungwaipi. You're there? No. Okay, along with Mr.?
My senior is Benjamin Lalsamona.
Along with Mr., your good name?
Lalsuanoma.
Lal Swan Oma, appearing on behalf of Mr. Benjamin, is it?
Yes, my lord.
He's a government advocate?
Yes,
Or
ma'am.
what?
Yes. Yes, ma'am.
Then Miss Caroline can be present along with Miss Caroline K. Lalungoipui, learned government advocate, okay, for the state respondents. In view of the submissions made, list after 2 weeks.
Oblige.
What about 5? What about all the others? All called? Okay, it's 1 o'clock. Oh. No, we'll finish it off. Why wait? Call 5.
Item number 5.
May it please your lordship. This appeal has been filed against the impugned judgment and order dated 7/12/2024, passed by the Court of Senior Civil Judge, Senior Division 1, ISO in CMA number 462 of 2023.
So this is the second time it's coming up, but no notice was issued?
Yes, earlier I was only in the other courtroom and it was left over.
Okay.
So,
But here it
notice may be
says that,
issued,
so
my
will issue notice?
Yes, my lord.
Okay. Heard, Mr.?
Zoram Sana.
Yes, heard Mr. Zoram Chana, learned counsel for the appellant, who has filed the instant appeal against the judgment and order dated 17/12/2024, passed by the Civil Judge, Senior Division -1, Aizawl District, Aizawl. Full stop. The learned counsel submits that the said impugned judgment is liable to be set aside. Why? 1 or 2 grounds?
My lord, because of the fact that the appellant is a government servant who was detailed to look after the contract work. However, the London Trial Court had directed the appellant to pay a sum of rupees 20 lakhs via ex parte order.
So have you the same?
I filed an application for
Setting aside the ex parte-
and it was rejected. Even though I have enclosed the name of the contractor, all the
Okay,
things that he
so
took.
the instant appeal is against the rejection of the ex parte order?
Yes, my lord.
Okay, who has filed the instant appeal against the rejection of the application filed as civil miscellaneous application number 462/2023 for setting aside the ex parte or judgment and order dated 13/12/2021. In civil suit number 51/2014. Stop. Issue notice to the respondents through registered post with AD within 3 days, returnable by 3 weeks. Yes. Vanessiami, you are,
Yes, my lord. Mr. Benjamin is one of the counsel out here.
what?
Private,
Or state.
No, we'll issue notice first. You and Mr. Benjamin is not there. Why should you? Or you're going to take up the what?
No, my lord, I will accept the notice.
Yes,
on
Ms.
behalf-
Vanessiami. No, we'll leave that later. Learned counsel, learned government advocate accepts notice on behalf of the state respondents number 7 and 8. Is it?
yes, my lord.
No need to issue formal notice to the state respondents number 7 and 8. List after 3 weeks. Accept notice first, then who is going to take up the case? You decide later. Isn't it?
Item number 6.
Obliged, madam.
Yes, your lordship. This is a bail application filed under section 37.
Okay, will issue notice. Heard, miss?
Sarah Ranwat Philip.
So and so. Learned counsel who has filed the instant bail application under section 37 of the NDNPS Act, read with Section 483 BNSS, 2023, praying for enlargement of the applicant on bail pending the conclusion of the trial.
My lord, the copy has been received by the learned APP.
The Learned Counsel submits that this is the third time that the applicant has filed the bail application. As the bail application filed earlier was rejected, void order dated 26/02/2024 in BA number 8 of 2024 and order dated 22/08/2024 in BA number 62 of 2024. Full stop. That the applicant has been in judicial custody for almost 1 year, for about 588 days since his arrest on 28/08/2023. Stop. What's the case number? Nothing mentioned? Where? In your synopsis? In which case? What case number?
Yes, my lord, arising out of SR Excise case number 390 of...
Oh, where have you mentioned that page?
Your Honor, the first page.
Since his arrest on so and so, wherein the applicant was charged under section. Where have you mentioned all that?
Front page.
Huh?
Your lordship, at the front page.
See, this is your cost title. You should mention it in your synopsis. You should mention it in your case, isn't it? Wherein the applicant was charged under section 21C of the NDNPS Act in SR within brackets EX close bracket 390/2023. Stop. See, in your synopsis or somewhere you mentioned that instead of us searching in the course title, which we'll see later. Issue notice to the respondents. Then Ms. Vana Isiami accepts notice on behalf of the state respondents. Requisite copy of the bail application to be duly furnished to the learned government to the learned additional PP. Okay. Vana Isiami, additional PP. In view of the work list after 2 weeks.
Your lordship, if the
After
matter
1
can-
week.
Next week.
Okay, list in the next week. It's a bail application. See? Then we don't have anything matter in the afternoon, is it? No hearing.